Thank you everyone for taking the time out of your day to learn with us. I want to thank Schwabe, Williamson, and Wyatt, the authoring firm of HRSimple.com's Oregon Human Resources Library, for providing our expert speaker today, Jean Omenbach. We'd also like to thank our partners at Associated Oregon Industries for sponsoring today's webinar. Associated Oregon Industries, or AOI, offers many tools and resources to help your business continue to thrive, including the Oregon Human Resources Library, which is on HRSimple.com. You can find out more about AOI's membership benefits at www.aoi.org. So here's today's agenda. We're going to give you a short introduction to our speaker. We'll then start the presentation from Jean. And if we do okay on time, which we should, there should be some minutes at the end to answer any questions you might have. Feel free to enter your questions in the chat box during the presentation as they come up. A quick note, if you're here for the SHRM CP credit, we'll provide a SHRM event ID at the end of this webinar for your credit. So to get things started, I'm going to kick things over to Jeff, and he'll introduce our speaker, Jean.
Hello, everybody. I wanted to tell you a little bit about Jean. Jean's a member of the Oregon and Washington State Bars, as well as a member of her firm's Hospitality Law Practices Group and Outdoor Industry Practice Group, the Defense Research Institute Employment Law Committee, and the Board of Directors for the Oregon Manufacturing Extension Partnership. She has practiced in the areas of labor and employment law and general litigation since 1991, and her practice is split between providing employment advice to company owners, managers, and human resources professionals, and in representing companies in lawsuits. In her advice practice, Ms. Back assists employers in all aspects of managing their employment relationships, including drafting employment agreements, drafting employment manuals such as the Oregon Human Resources Manual, providing supervisor and employee training, advising employers on the interaction of employees' rights under the Americans with Disabilities Act, the Workers' Compensation Act, and state and federal family leave laws, and pregnancy leave. Ms. Back regularly assists employers in responding to charges before the Bureau of Labor and Industries and the Equal Employment Opportunities Commission.
Thanks. I guess that's my cue. Welcome, everybody, to this webinar. I'm happy to have been invited to participate and present for you today. This is a topic I present on frequently. It's one that I try and keep up on and just follow everything that is going on in this area. So without further ado, let's get to the agenda. We kind of have a very aggressive agenda today. I'm going to try and cover everything to the best that I can, and hopefully you'll chime in on your chatting, which is a feature that you have here. If there's additional questions that you have, please go ahead and ask them as we're going through this, and we'll try and get through the topics. So the first thing that we're going to cover is privacy and social media issues in hiring. We're going to then move into employer monitoring, off-the-job behavior, sources of privacy rights. We're going to kind of go through that, sort of quickly, because that's just a background for you to understand what kinds of claims your employees can make. Then we're going to talk about identity theft, which is a kind of new and rising area. I'm going to give you some recommended workplace privacy guidelines. We're going to talk a little bit about information disclosures, and that's really kind of the data breach area. And then a little bit about workplace handbooks and agreements and some privacy issues that have come into that area recently. So privacy issues in hiring. The first thing that we want to talk about here is whether you should Google a job applicant. And we do have some poll questions that we're going to be talking about here. And so we have one up on the line, and that is, does your company research job applicants online? And so you all have the ability to check yes or no or to that, and then we can all learn as we move forward here what kind of practices are in place across the nation, because whether you all know it or not, there are about 192 of you who have signed up for this, and you are all over the country. in every type of industry. So it'll be interesting to see what the votes show up here as we continue moving forward. I'm going to continue talking, though, I think, as the poll progresses. And Eric, are you there? Yeah. He's going to bring up the what we've got here now. So does your I'm not sure how that poll is working. So I'm going to move right into the presentation here. So should you Google a job applicant? What we know is that from the research that's been done through SHRM and other areas is that at least 43% of companies check out candidates' profiles on sites such as Facebook and MySpace before they're deciding to employ employees. 33% of employers surveyed have said that they hire employees based on their social media networking profiles. So that's like what they've found on these websites that they're checking. And then 51% of employers surveyed decided not to make a job offer after reviewing those social media profiles. So the questions that come into play are, are you allowed? What are you allowed to do in terms of looking at these websites and trying to find information about people online? And the general consensus is that there isn't any law that prohibits employers from reviewing publicly available information about employees or applicants. So anything that's out there, if somebody is posting online and they're going onto a blog, they're posting onto a public site that doesn't require a password, then you're allowed to look onto those sites and get information about it. Likewise, if they open up their sites like Facebook to the public and they don't have any privacy controls on those sites, then you're allowed to look at those sites. But it has to be publicly available in order for there to be no privacy implication with respect to that information. But then you also need to consider when you're doing these online searches that some things that you might find online are not accurate. So you may see something posted about an applicant online. Maybe somebody has said something about that applicant. And it turns out that that information is incorrect. And so the question is, do you want to be making employment decisions based on information that you don't know whether it's accurate or not? So you do need to have, kind of have some idea of what you're looking at and what sites you're looking at, and be able to decide whether the information that you're looking at is accurate or not. And the kinds of risk assessment that you want to be doing when you're looking at this is, what's the value of learning more about the job applicant versus the risk of the impermissible information that you're getting? I think that we'll do a second poll, and hopefully I'll do a better job of keeping it up, and so we can all figure out what the information is on it. But what I'd like to do is put up a poll about if for those of you who do online research, when do you typically choose to do this research? Is it before the first interview? Is it after the first interview? Or is it after all the interviews but before you make your first job offer? So these polls are still coming in, and we'll wait a little bit until we get some of these answers. So it looks like what we've got here, I don't know if everyone's finished voting, but it looks like 38% of those, 37, it's going up, kind of look at research their job applicants before they do their first interview. 24% of you currently are doing it after the first interview, and about 36% of you are looking at it after all interviews but before making a job offer. Now, some of these numbers have changed. 39% now before the first interview, 23% after the first interview, and 36% after all interviews but before making a job offer. So it looks like the majority of you are doing this actually before the first interview. Okay, so going into, so we're going to talk a little bit towards the end of this about when you should be making those when you should be actually doing the looks online for people, and when the safest time to do it is. What I want to talk to you a little bit about right now, though, is about the pros in your risk assessment that we talked about earlier. What are the pros of actually doing this online search? And some of those pros include you're going to get valuable information about employees. You're going to learn about whether they have poor judgment. You're going to learn about potentially whether there's illegal drug use that is going on. You're going to, and one, I think the most valuable things that I find my clients talk to me about is they're going to learn whether this employee or potential employee is making negative comments about their current employer or negative comments about the employees that employer employs, or about the employer's customers, or even about the employer's trade secrets. That type of information is very valuable to learn about a potential employee, because obviously, you're not going to necessarily want to employ somebody who is making negative posts about and disclosing trade secrets online. So that's all part of that judgment that you're going to find out about the kind of judgment that this employee or this potential employee uses when they're online. Also, angry or violent posts, that's a really important thing to know about, and we'll get into that in a little more detail in a few slides, because we're going to be talking about negligent hiring and sort of negligent retention claims. But this is something that you're really going to want to pay attention to. And negative admissions, if they say they lied about absences, you find that online all the time, unfortunately, where someone might say that they called in sick to work today, but they spent the day at the beach. So those are all types of things that are valuable to you that you can learn about online. I told you we were going to talk about negligent hiring claims, and this is a type of claim that we employment lawyers are seeing all the time. They usually are added on to discrimination claims or sexual harassment claims, especially if those claims involve some type of violent activity in the workplace. So a negligent hiring claim is a claim that occurs where an employee is, in the course of his or her employment, injured another person in some way. And the argument is that had you done an adequate background check, you could have discovered the information about this employee's conduct and not hired them. So this is another reason why you want to do background checks, and why, like a lot of employment attorneys and employers alike, are a little upset about all of the EEOC guidelines on background checks and some of the restraints that you have in checking people's criminal records prior to hiring them. Okay. So other limitations that you might run into if you're doing these types of online searches. The biggest limitation is you're going to find out about problematic information that you didn't necessarily want to know about this employee prior to interviewing them, or prior to at least making a decision about whether you're going to interview them. So if you're going online, you could see pictures of the person that's posted on a blog or on a Facebook site or some other place online, or even discussions where you're going to be able to learn that person is over 40. Or if you're in Oregon, we have a weird law that says that there's age discrimination if you're under 18. So, that's another issue. I don't know if other states out there have that same odd provision in their age discrimination statute, but we do here. Other things you're going to learn about is their political leanings. You're going to learn about whether they have potentially a disability or a medical condition. You may learn about their sexual orientation, about religious affiliation, or genetic information. You may find out that they have a mother that has breast cancer, so that's genetic information. So all of this information is information that you don't really necessarily want to know about an employee before you make the decision to interview them. Okay, so what we recommend is that if you're going to do online searches, you want to establish screening guidelines. And so first of all, you want to search only final candidates. So for those of you in that poll that answered that when you're doing the search, you're only looking at candidates after you've done the last set of interviews, but before you make the decision to hire them. That's when you want to do this search, because then there isn't the same argument that if you find out about their age or some other protected characteristic of this person, you're automatically not even interviewing them because you know that. So it takes away from the discrimination element that could come up. You also want to have a non-decision maker do the search. So assign that to someone in your HR group or whatever however you organize that part of your company that isn't going to be the person that is making the decisions whether to hire that person. That way, that person may find stuff online, but the only thing that they're going to let you know about is the really important stuff. Oh, by the way, this guy posted a post that said, that he hated all of your customers, or made a really derogatory remark about a coworker or something like that. Those are the things you're going to want to know about, not any of the protected characteristics. So having somebody that isn't making the employment decision do that search, they can screen out all of that other stuff. Doesn't matter that they saw it, but it matters that the decision makers see it. So that's the important part. Create a specific list of red flags. So for that person that's doing the search, what's important to you? Make a list of those things. Illegal drug use, violent tendencies, that should be on the list. Poor judgment. What kinds of things might establish poor judgment in your mind? Posting these types of things about your trade secrets or whatever, or their current employer's trade secrets. So those are all very important. So another way that you can protect yourself if you're doing screenings is even before you, maybe even in your employment application, on your application or in your advertisement, let these potential candidates know that your practice is to perform an online search, to kind of get an indication of, kind of screen them out, essentially. And in doing so, that does give potential applicants an opportunity to go online and clean some of the stuff up that shouldn't be there, like maybe a picture of them drinking. They don't want that online, so they'll take that off. Not all applicants are going to be savvy enough if something is on your employment application to go online and clean up their online profile. But it does, that is something that can protect you and give you some help. So don't ask for passwords or access to passwords to protected sites. You're not allowed to do that in many states. In Oregon, you're not allowed to do that. It's against the law. So just refrain from doing that. Don't ask applicants or employees to friend you. That's another thing that is against the law in many states. So, that's something that you shouldn't do. Okay, so now we're going to move into another area, and I don't know if many of you have heard of the EEOC uniform guidelines on employee selection procedures, but you can Google that and get into those guidelines. And they're used by the EEOC essentially when they're looking at Title VII cases to kind of figure out whether there's been discrimination in the selection process for purposes of Title VII. So we're talking about record-keeping requirements here, and we're saying that due to the possibility that an online search will be considered a selection procedure under the EEOC's uniform guidelines, you're going to want to keep information on your online searches for a little while, and for at least probably 2 years, which is what is required under this EEOC guideline. Again, this guideline is just a guideline, so it's not the law. It is what the EEOC uses in kind of making their decisions on Title VII. So there is this retention period that they have, which is 2 years for employers who are federal contractors and 1 year for employers who have less than 150 employees or who do not have a contract for at least $150,000. Okay, so I'm going to move into electronic resumes and video applications. This is another really new area that we're all finding ourselves in because now we're not basically applying for jobs in the same way that we used to. Jobs are posted online, and we're applying for them online. And likewise, the newer folks that are coming into the job markets are essentially creating little video clips about them and kind of describing who they are and what they do on a video clip. And so what does that do? If you're getting a video clip or an online resume, something that shows what the person looks like, it's the same kind of concern that we had about actually going online and finding someone's protected characteristics online. You do see, you can see whether this person is in a protected class by looking at these online or video type resumes. So one of the things that, we ask about when we're deciding whether we're going to even take a video resume, which is something that you can say, I'm not going to take those. Please don't send me a video resume. And, in doing that, that does kind of help you eliminate part of that discrimination issue that you could run into. But one thing we ask is, if you just some employers, will post a job or not even post a job. They'll just have people that are just so interested in working for them, they'll get these online video clips without even posting a job. So one thing that we ask ourselves is, who is the applicant? Is that person an applicant? What do you actually have to do to be an applicant? So to be an applicant, the following things have to occur. The employer has to have acted to try and fill a particular position. So that initial example that I gave you, somebody just sending out a video clip where there was no job posted and the employer had no intention of hiring anybody, that person isn't going to be an applicant under the EEOC's rules anyway. So you have to have acted to try and fill a position. That means you've let the public know you have a position that you want to fill. The individuals followed your standard procedures for submitting an application. So you've said, here's what I want you to do to submit the application. I mean, if you want to take video clips, you can say that. But if you don't, you can specifically say you're not going to look at any video clips, and you won't look at those. You'll just discard them. If they don't follow your guidelines and your procedures on how to apply for your job, the question is, are they going to follow your guidelines and procedures in other areas once they become an employee? So you don't have to look at the video clip. And the other thing is, the individuals indicated an interest in the particular position. So all of those things have to have been met in order for them to be considered an applicant. So the EEOC has indicated it's not illegal to obtain protected information about an individual prior to an interview. So we've talked about that as a risk, but that having that information increased the risk of a discrimination claim. So where it's not per se illegal to obtain that information, and quite frankly, there are many instances where you will have, in some cases, no choice you've got the information. It's going to become available to you and you can't screen it out. So it's not illegal to get it. But what they're saying is we can still apply that, even though it's not per se illegal. It can be a factor in assessing whether discrimination has occurred. Okay, I hope I've answered some questions for you on this whole first issue about whether you're going to Google a job applicant and some of the newest ways that people are applying for jobs and how you deal with that. We're going to move right on into employer monitoring, which is one of my favorite areas. So employers, the general rule with respect to employer monitoring is that you can monitor your employees in a variety of areas as long as it's on your company-owned system. So we're looking at, for instance, emails sent and received in this slide. But generally, as long as the monitoring is occurring on your own system and as long as you have a comprehensive electronic communications policy where you explain that you are going to monitor. By explaining in a policy that you're going to monitor your employees, you are acting to dispel any right of privacy that they have to communications that they send through your system. So that includes not only emails, but it includes text messages if you own the phones that they're working with. Or if they have a smartphone and it's their phone, but they're accessing information, their emails or whatnot through your system still, then you're allowed to monitor those, even if it's their own phone. So that's the general rule. And there's several reasons why employers might choose to monitor their employees, and they're actually very valid, good reasons. So for one, you may want to monitor your employees to make sure that they're not disclosing trade secrets. And quite frankly, if you have trade secrets and you want to protect them, you really, in order to be able to protect them and to file claims if people are disclosing trade secrets, you're going to need to be able to prove that you took efforts to try and protect your trade secrets. So having an electronic communication policy that specifically mentions people are not allowed to disclose trade secrets online, and also monitoring your employee communications to make sure they're not disclosing trade secrets. Those are all things that you can argue if you had to at some later point in time that you did in order to protect your trade secrets. You may also do it to protect the security of your company's computer and data systems, and that is, you want to make sure that people aren't uploading documents or going onto websites that's going to all of a sudden cause you to have a terrible bug in your computer system that is going to, wipe out your computer system, or that is going to cause you terrible problems. And we've all seen that happen time and again. And so, this is another reason why it's important to monitor your computer systems. You want to guard against and reduce the risk of liability for sexual harassment. So you want to make sure, people aren't posting things or sending things to each other that are sexually harassing. You want to prevent a loss of productivity, potentially by monitoring whether employees are using the systems for personal or non-work activities. That one's a little hard these days anymore because, we all basically do use our computer systems for both work and non-work activities periodically throughout the day. However, I do have a lot of clients that do have rules that you can't do any non-work activity on our computer systems, and that's a really hard one. If you're gonna have a rule like that, there's no problem with it, but you need to be able to enforce it. And the only way to be able to enforce it is to know whether people are actually using your system for non-work activities, which requires you to monitor to figure out whether that's happening. You may also want to monitor to keep time records, track inventory, or track employee activity. We're going to get into that in a little more detail with some very, very new ways that employers are starting to monitor their employees. And these are things that I am just starting to get calls from my clients on. So I think this presentation is going to be maybe one of the first where you'll have heard of some of these areas. Okay, so we've talked about employers making sure that you have a great, good electronic communications policy that indicates that you can monitor telephone calls through your systems, and that indicates all the other areas that you're going to be monitoring employees. And again, we're going to be getting into some of those areas. So if you're starting to monitor employees in these new areas, you're going to want to add that into your electronic communications policy. And I am looking at these chat things. It's hard for me to both go through the slides and actually read all these chats at the same time. But I see one from one of our persons that does say that another reason she monitors employers is loss of productivity regarding the internet. And she's saying it's especially difficult to do that. So that's she finds that that's a really hard area to enforce, and I think a lot of you would probably agree with that. We're going to talk about one of the new Supreme Court cases that's come out in the last several years regarding this monitoring issue, and this is the City of Ontario v. Kwan, and you probably have all heard about this case. It is a case that comes out of Oregon, but it was decided by the United States Supreme Court, and basically this was a case where the police department in Ontario, Oregon, provided their police officers with cell phones, and they allowed the police officers to do to text on the cell phones. And as the auditor for the City of Ontario was going through his bills, he was seeing that there was a lot of texting going on these phones. And so they started to look into the texting and what people were texting. And they found that they weren't just texting, they were sexting. So there was a lot of sexual innuendo, discussions, connotations back and forth on these cell phones. And so essentially the city of Ontario moved forward and started to make some employment decisions based on the sexting that they discovered. And the police officers filed the lawsuit and said, look, I have a right to privacy with respect to my text messages, and you're not allowed to look at that, and you violated my Fourth Amendment right. Now, keep in mind, this case dealt with a public entity, a police force. So police forces and public employees do have rights under the Fourth Amendment of the United States Constitution, privacy rights under that amendment. Though private employers and private employees who work for private employers do not have rights under the Fourth Amendment. So that makes this case and the context of this case not applicable to all private employers. But the really important part of this case deals with the fact that the Supreme Court basically, so we don't really care so much about the Fourth Amendment issue. What we care about is that the Supreme Court looked at this case and said, no, you know what? Employers have employees, even these officers, who had Fourth Amendment rights, have no right of privacy with respect to text messages if they're on employer-owned systems, and if the employer had a good electronic communication policy that basically said you have no right to privacy with respect to these communications. So that's Kwan, and Kwan was a great case that helps employers out in the privacy field. Okay, so I think we're going to put up another poll here as we move forward. And one of the things I want to know about from all of you out there is, does your company monitor employee emails? And I don't see the poll coming up here. If it doesn't come up, we'll just move on. Doesn't look like it's coming up. Okay. Well, we'll continue on employer monitoring. So we're talking here now about recording telephone calls. And the question is whether you have a right to record the telephone calls that your employees have. And the advice that I can only give to you as a national group here that I'm presenting to is you need to, here's our poll. Sorry about that. Okay, so does your company monitor employee emails? If you could all just kind of let us all know where employers stand in that regard. It'd just be interesting to know. We'll let everybody chime in on it. So it looks like the numbers are starting to slow down as they're coming in, and it's pretty even. That's pretty interesting, I think, because I've never really. I have a lot of clients that do monitor phone calls and clients that don't, or emails especially. So it's interesting to see that it's pretty much even with what you guys are doing. Okay, so we're going to get more into monitoring emails in a minute, but I wanted to move back to monitoring telephone calls. And one of the things that you need to decide for your own state, and this is a state-to-state issue, does your state allow you to record telephone calls? Here in Oregon, that's where I am, in Portland, Oregon, we can record telephone calls as long as one party consents. And so that's a weird rule, because as long as the person that's actually recording the telephone call, they're one party. As long as they consent to recording the call, which they obviously do if they're recording it, then you can record the call. Some states have both parties have to consent. So you need to be very careful about that and make sure that you're doing it and following state law. But you can't, whereas you may, in some cases, record telephone calls, it's illegal to obtain or attempt to obtain part of a telephone communication or a radio communication in which the person recording is not a participant on the phone. So if you're recording it and you're not a participant in the call, so you're not consenting, that's the Oregon rule, then you can't record it. Okay, so we're continuing with employer monitoring. And so one of the things that some employers do is they monitor keystrokes. And they do this for a variety of reasons. They want to figure out maybe whether their employee is consistently working. And this, obviously is only going to deal with employees that are sitting at their computer and maybe doing data entry or a secretarial type position. But you want to see that your employee is actually sitting there and actually working. And so you can monitor. There is computer software, and you can monitor keystrokes and figure out what's going on with your employees. And sometimes you can put those keystrokes together and actually figure out what they're actually typing as well. So if you're monitoring keystrokes, the one thing that you can't do is, for instance, you couldn't get an employee's private password to a protected site while you're monitoring keystrokes. And there was a case that involved an employer doing that, and the case ended up, finding that was activity that you couldn't capture an employee's protected password and then go on to that password protected site that you discovered through the keystroke monitoring. Okay, so we've talked about this rule that employers are allowed to monitor internet use on your own system. So we won't belabor that any longer. I think that that's been clear. In emails, you're allowed to monitor emails sent and received on your systems as long as you have the electronic communication policy. We talked about that as well. So here's a brand new thing that has come up recently with respect to monitoring employee emails. And this Purple Communications, Inc. is an NLRB decision. And it is a decision that was put out by our now very, very, very liberal, democratic, if you will, NLRB. And it's changed a lot from the National Labor Relations Board that was in play, before President Obama came into office. And so prior to this case, we had a case called the Register Guard case that essentially said that you were allowed to monitor employee emails, and really kind of gave an open book on that. The Purple Communications decision, which was just decided in December 2014, has held that an employee's use of an employer's communication systems during non-work time for concerted right activities, that is, to communicate with coworkers about the terms or conditions of employment, are allowed under Section 7 of the National Labor Relations Act. In other words, employers are not allowed to monitor an employee's non-work email communication when it's dealing with concerted rights activities. And hopefully all that isn't a new phrase for all of you, and I'll just do a little bit to explain it to those of you that don't know it. But concerted right activities come from Section 7 of the National Labor Relations Act. The National Labor Relations Board is the board that is responsible for implementing the National Labor Relations Act. And the National Labor Relations, Section 7 basically says that employees have the right to discuss the terms and conditions of their employment with their coworkers. It's the water cooler kind of conversations that employees had back in the day when there was no email. And so they're allowed to complain about their wages. They're allowed to complain about their supervisors. They're allowed to complain about their jobs. They're allowed to do that on emails. So basically, you can't prevent that kind of activity during non-work time. So Purple Communications, again, an employer who allows an employee to use its computer system may not prevent an employee from communicating about union activities. So Purple Communications is more of a union case, and it does deal more in the union environment. But because it also deals with that Section 7 of the National Labor Relations Act, it can apply to all employers and not just union employers. In other words, Section 7 of the National Labor Relations Act applies to all, well, most. I won't say all. There are some limitations, but it applies to most private employers. So you can't prevent employees from communicating about union activities, including organizing a union, to form a union, as long as those discussions occur during non-work hours. Now, there are some exceptions. The Purple Communications System said there could be a special circumstances exception that would allow an employer to completely ban the non-use work of email. But that exception, first of all, they didn't explain what it was, other than this one statement. They didn't articulate what might constitute a special circumstance, but they did say that it would rarely exist. So what we know about the special circumstances exception now is that it's probably not going to be very helpful to most employers. It probably isn't much of an exception at all. Okay, so I'm going to move away from email type monitoring. I'm going to move into what I think is kind of the newer, more cutting edge monitoring type of activity that employers are doing now, and that is monitoring employee movement. And so first of all, we see employers more and more using GPS monitoring to monitor employee movement. And so this monitoring uses these global positioning devices, much the same as some of you may have in your cars, to kind of tell you, MapQuest or whatever that might help you know where you're going in your car. Employers can have global positioning devices in cars to track the locations of their trucks when they're out in the field. They can track whether their drivers are getting to locations in a timely manner. And they can track other things about the location of their employees or vehicles. So several states now have started to develop laws saying that, that address the tracking using GPS devices, because some of these monitoring devices that are coming into play now are more and more intrusive into employees' kind of off work privacy related lives. And so now we're really getting into this situation with a lot of the new monitoring devices over how far can you go before you're actually breaching an employee's private rights. So the states that have addressed this are California, Minnesota, Tennessee, and Texas. And essentially, they all have laws that indicate whether you can or can't do this. And a common exception in these laws is providing notice to the employees. So, in other words, if you're putting a global, like say you decide you want to know, where an employee's going. They're supposed to go to a meeting and you have some idea that they're not going to this meeting, a sales meeting or something like that. So you stick a global positioning device in their briefcase. You don't tell them about it. That is not going to fly in California, Minnesota, Texas, or Tennessee, and it may not fly in even other states that don't have these statutes. Unless you provide notice in the form of a policy or some other memo or some other way of providing notice, that you are going to be monitoring them and their movement. And, so especially if it's something that you do all of the time, you would want to provide notice. I still think if you're sticking a GPS device in someone's briefcase, you might have a problem, even if you did give them notice, because they have no idea at that point that they're being monitored, whereas somebody in a truck is going to have notice probably that they're going to be monitored. I did get a chat question here. Does Oregon allow a GPS device on phones without employees' knowledge? And on phones, it wouldn't really, I think if you're talking about cell phones, I would say that goes to the same thing as a briefcase. That's different to me than putting it in a vehicle where the employee is supposed to be traveling like a UPS driver or someone like that making deliveries. That is, I would think, a very good use of a GPS device because you need to know where people are in the field. Cell phones is a totally different thing, and I think that you're going to have a harder time finding that there's a legitimate business reason to put a GPS device on somebody's cell phone. But we're going to be moving more into that kind of question as we move on. And so now we've got the slide up for radio frequency identification devices. They're called RFIDs for short. And these are devices that use wireless communication and radio frequency bands to send information to readers that store the information for personal use. And so where you see these is key cards. So if you have key cards that people use to enter and exit your building, then that's using this radio, this RFID, and that information is going to go to some sort of server or some sort of database, and it's going to be stored. And then if you want to know, you know when your employees entered and exited your building, and that's very powerful information. That's information that I would say you want to have. You want to know that, especially to fight wage and hour claims, because you might have an employee that says, "Oh, I was at work. I'm a non-exempt employee, but I had to work overtime and I worked these hours," and you never told them to work overtime. Maybe they're saying they came in on a holiday. Maybe you don't have a policy that says you have to get permission to work overtime. And it's your job. I mean, it's the employer has the burden of proof on that to show that they were not at your premises working overtime. Well, you could have the information in order to fight that claim if you used these key cards with these radio frequency devices. So what I'm saying is that there's very good reasons to have this type of information. They're also used, and I've got this slide up now that shows different ways that employers do use it. You see the key cards. You see that some employers use it by scanning product that's in their warehouse. That's another, and employers use that all the time, not just for employees, but to scan their product and to know where their product is. Schools are using these RFID devices to monitor who's coming in and out of the schools. And you see this one with the chip. I mean, this is the newest thing. And, again, I don't think very many employers do this or ever would intend to do this. But in some cases, you can actually embed a chip into somebody's body, and that they can then scan using their hand. And that's RFID use. Again, that's kind of way out there. I've got another question here. If it's not allowed and they don't consent, I think you're talking about the RFID, and they don't consent, is there retaliation protection? And I guess you're asking is, can they make some sort of claim that you're retaliating against them for something? The retaliation has to be based on something in order. That's the definition of a retaliation claim. It's retaliation for something. So in general, you may more get a discrimination claim of some sort, or the claim that you're going to get. We're going to move into it in a minute, and I'm going to have to move through these slides a little more quickly if I want to keep this down to an hour. But you're going to get into intentional, kind of breach of privacy claims. So that's going to be the type of claim you get more than a retaliation claim. Okay, so more into RFID monitoring. This is just some statistics that I found. The RFID market is expected to triple between 2013 and 2020. Right now, it's primarily used for inventory management and in corporate supply chains, but the people are using it to track employees, and some companies are using it to study employee interaction and productivity. So what they're doing is they're studying, and it was one study that I saw that was in a hospital setting where they were looking at employees' interactions with each other, and somehow they were using these RFIDs to monitor who was talking to each other at what time. And so that was a very interesting study online. So there is legislation in a lot of states on RFID monitoring, and this is as of December 16, 2014. That's the most current update that I could find of state legislation. California, North Dakota, Oklahoma, and Wisconsin prohibit being able to implant an RFID microchip, which shouldn't surprise us. I mean, that seems awfully intrusive. Alabama, California, Illinois, Nevada, Utah, and Washington prohibit unauthorized skimming of RFID ID cards. And that happens when people are just walking. You have maybe a scanner set up, and they're walking by an area, and you skim the information as they're walking by the area, maybe not even of your employees. This actually, I think, deals more with skimming of even the public. You can somehow skim off of RFID cards to kind of gain information and data about who, say, is walking past your store or something like that. Arizona, or Arkansas, so the next set of states here have laws that related to the use of RFID in driver's license or vehicles. So not all of these things deal with employment issues. And the next set of states there, including Oregon, have laws that prohibit or regulate monitoring or tracking of students. So, okay, so the next kind, so we've talked, about GPS and RFID, and essentially the idea is that obviously monitoring employees off work hours, even if they're using employer equipment like the cell phones that the other one writer asked about, is an invasion of, it's probably an invasion of privacy, because you can learn information if you're monitoring people off work through those mechanisms, like if they're visiting a hospital. You can learn their shopping habits. You can learn whether they're going to a gambling casino. You can learn what church they're going into. You may learn about their eating habits. So these are all things you really don't want to know about somebody's personal life that you can glean through this off-work monitoring. So reasons why you wouldn't want to do it. So you want to basically limit information that you collect to an employee's job performance, i.e., the delivery person's timeliness in delivering their product. And you need to consider, if you're going to do this, having a policy that sets out legitimate business purposes and circumstances under which you're going to do this monitoring, so that you can dispel a right of privacy. So we're going to move into biometric data. This is another area that's really new, and I've gotten some questions from my clients on, so I know that people are looking at it. And so we're talking about hand scans and retina scans. And I know, my gym has a fingerprint scan that I have to use when I go in there. But the problem with that for employees is that you're collecting biometric data. You're collecting their fingerprints. You're collecting their facial recognition, their voice recognition, their retinas, and or their, how their retina is formulated. And you can use, a lot of companies that are using this is instead of to verify their clocking in on their times, or as a secure way of entering buildings. The problem with it is that this information can be hacked, and if it's hacked and stolen, it can be used. It's an identifying characteristic of a person, and it's just like somebody's social security number. You can steal that part of a person's identity. So that's where the problem arises with respect to biometric data. So several states have enacted legislation regulating its use. Currently, Illinois and Texas have very comprehensive statutes. These other states listed down here include biometric data in the definition of personal information for purposes of data breach and notification laws. There's also this case, an EEOC case, called EEOC v. Consol Energy, where the EEOC found that an employer who wanted to use a biometric scan, a hand scan, and the employee, who was an evangelical Christian, believed that having his hand scan had a connection to the mark of the beast. The EEOC found, and so the employee filed a religious discrimination claim. The EEOC faulted the employer for failing to accommodate that employee's religious issues and using some other less intrusive means of determining whether the employee was at work or not. So I'm going to move a little quickly here because we've still got a lot of slides to cover. But best practices, if you're using these kinds of monitoring devices that we've just talked about, establish a policy letting your employees know that you're collecting the biometric data. So notice. You have to indicate a specific legitimate business purpose. You have to obtain a release to collect the data. You have to establish a retention, some sort of retention policy. Now, this is required in Texas and Illinois based on their statutes, and I think that even if you're not in Texas and Illinois, it would be worth looking at those statutes and following them, because I believe other states are going to probably emulate those statutes. So establish a retention schedule for that information and destroy it after a certain amount of time. Use reasonable care in storing data, especially data that has somebody's retina scan or that type of thing, and have a system in place in case there's a data breach. Okay, we're going to move quickly into off-the-job behavior, and I'm going to kind of move through these a little quickly, and I apologize for that. Just want to be able to get through this material for you. So off-the-job behavior may include things like moonlighting, criminal activity, drug and alcohol use, internet activity, union activity, political activity, immoral or unethical behavior, maybe, something that, an employer would find not to be consistent with their culture or what they're trying to personify as their culture to clients and people that buy their services. So the three kinds of questions you want to ask when you're looking at off-the-job behavior: is it lawful for me to take the action? Otherwise, can I regulate the conduct? Is it wise for me to take the action? Should I regulate the conduct? And can I be sued? Have I followed best practices? And so, can I regulate the conduct? This question involves looking at your state laws and determining whether you have state laws that affect whether you can regulate things like, affecting stuff like marital status, religious, sexual orientation, off-duty tobacco use. There are many states that do have laws. I think California does. Or marijuana use. There are many states now that have legalized recreational marijuana, Oregon, Colorado, I think Alaska as well. So you want to look at, whether there are laws in place, wage garnishment, all of these types of things that are listed in this slide. And then you want to look at privacy considerations and be particularly cognizant when you're investigating off-duty conduct. And the general rule is that if you merely observe, if you observe conduct that's out in the open, that's not private. But if you're using surveillance to observe the conduct, for instance, the global positioning devices or the RFID devices, then that could violate an employee's privacy rights. So you have to be careful. And you need to determine if there is a legitimate business reason for doing it. This is a list of things that can be considered legitimate business reasons. The conduct would damage the employer reputation. The conduct causes workplace disruption. The conduct harms employee morale, prevents an employee from performing their job functions adequately, or presents legal liability to employees and third parties related to the off-duty conduct. And so then your third question, should you regulate it, goes back to the legitimate business reason. Can the off-duty conduct cause you harm? If it can't cause you harm, then there really probably is not a good reason to regulate it. So best practices, if you're going to look at off-duty conduct, is to create a policy that governs this kind of conduct. And so a lot of employers have policies regarding moonlighting. I hope all of you have policies regarding drug and alcohol use. Criminal activity is another area where you may have a policy. You all probably have that electronic communications policy, which is the internet policy. And if you have anything that you consider a trade secret, then hopefully you'll have a confidentiality policy. And then you'll need to consistently enforce those policies. So I see we've come up to the 12 o'clock timeline. I'm going to continue for a couple more minutes here. If you need to drop off, feel free to do that. And I think there is going to be a way to get you the slides. So if you did miss some of the slides, those are going to be able to get to you. I'm going to move quickly through these sources of privacy rights. We've talked a lot about some of them. The Fourth Amendment right I'm not going to dwell on because we've talked about it. Public employees have a right, privacy rights under the Fourth Amendment, if they have a reasonable expectation of privacy. And again, there's no privacy right, though, to employer-owned systems. So the sources of privacy rights are intrusion upon seclusion, public disclosure about private facts, false light, and appropriation of another's name or likeliness. Now, these are all the types of claims that you would get for breach of privacy. I am going to skip through these slides. Again, they're going to be available to you if you want them. But essentially, these slides just go through the elements of these various claims into the sources of privacy rights, but most of them do involve something like an intentional intrusion. That can be like a drug and alcohol policy, like getting someone to put a chip into their can. Those are all can be considered intentional intrusions. If it's on their solitude or seclusion, which is highly offensive to a reasonable person. So those elements kind of flow through a lot of these various areas. We've talked about these are the things that can cause situations where you can get intentional intrusion. If you give notice to an employee that you're going to monitor, again, that helps you. Public disclosure about private facts occurs when an employer makes a public disclosure, and it usually happens if you disclose like a health record, and that was unintended. The false light happens usually when you're giving a reference check and you say something that puts the person in a false light, and it has to be a false or misleading statement, so it's not a true statement. And appropriating another's name or likeliness happens if you use pictures or their statements or something like that. You need to get you need to get authorization to use somebody's likeliness. Okay, the Electronic Communications Privacy Act, I'm going to move really quickly through this. The really thing that you need to know about is the Stored Communications Act. The Stored Communications Act essentially is another area that employers can be sued on for violating privacy rights. And this happens if you it basically prohibits third parties from intentionally accessing electronically stored communications, which includes emails or private websites. So essentially, the Stored Communications Act prevents you from getting somebody's private password and then using that password to go into a site that you're not allowed to go into and that you haven't been given permission to go into. So if that happens, you can be sued under the Stored Communications Act. You can also be sued if you access something in a server that isn't your server. So a third-party server, and you access that somehow, you can be sued for violation of the Stored Communications Act. There is an exception if you're given authorization, but the authorization has to be a true authorization. It can't be one where the employee is compelled to give you authorization to get their password. So there have been a few cases dealing with the Stored Communications Act, and these all arise out of basically going on to websites where an employer wasn't given authorization to do that. They may have been private employee-created websites, and the employer supervisor somehow got onto that website and then terminated an employee based on statements on that website. That's what this Pietro case was about. The Canop v. Hawaiian Airlines case was again about accessing a secured website. This happened to have been a website created by the pilots of Hawaiian Airlines to kind of complain about Hawaiian Airlines. And and then the next one, Pure Power Boot Camp, dealt with an employer finding an employee's password after the employee had left. It was sitting on their computer, and they used the password, and then they found information that the employee had started his own company, and they filed the lawsuit on that. And the employee counterclaimed in that lawsuit and argued that the employer's access using that password that was left on their computer violated the Stored Communications Act. So those are all examples of where that can happen. Identity theft, 23 states introduced legislation regarding identity theft. Oregon has an identity theft law that basically protects personal information about consumers. I'm not going to spend a lot of time talking about the Oregon law, only because not all of you are Oregon folks. If you are Oregon and you're on the line, please email me, and I'd be happy to send you more information about identity theft as it relates to Oregon. We only have a few more slides left. So data breach. We've talked a lot about data breach in this webinar. And so one of the things we wanted to talk to you about is having a data breach plan. And the issue is not whether there's going to be a breach at your place of employment. It's just a matter of when it's going to occur, because breaches happen all the time and more frequently. So if this isn't something that you're in charge of, it'd be worth you going to whomever is in charge of it at your place of employment and asking, do you have a data breach plan? What is it? If we don't have one, why don't we create one? So if you're creating a data breach plan, you want to include people like IT, HR, and legal and auditing. You should all be in a room together talking about what you need to do. And it should include what do you do in the worst case scenario for an immediate response to prevent continued breaches. And this is a whole nother topic. I could do a whole nother webinar on it, but the point of this is just to inform you about it and to let you know that if you don't have one, you should have one. And if you're interested in more about it, I'm happy to have a chat with you offline about that and give you some more information about it. If you're doing a data breach plan, what you do want to do is you want to be able to have a plan or something in place where you're going to be able to notify your employees right away about the data breach. You're going to want to determine whether you will offer credit monitoring or other ID theft insurance to employees if their identity is stolen. You certainly want to give them information on how to get their credit checks and how to monitor the credit checking agencies to make sure that that their credits aren't being stolen and used. And you want to work closely with the PR company to message what's going to happen with the press about this data breach, because companies like Target and Michaels and other companies where this has happened, they've been big deals. So you also want to determine if you need to alert law enforcement about it. Okay, just a few words here on privacy guidelines. This is just overall privacy guidelines for all of what we've talked about. Inform your employees in writing about the ways you plan to monitor them. Have a comprehensive electronic communication policy. Consistently apply all of your any monitoring policies across all employees. Don't just choose women. Don't just choose people in one ethnic group. Of course, that's going to get you in trouble. Justify monitoring your policies by including the legitimate business interest that supports the monitoring activity. Okay, these, again, I promise these are the last slides. This one just deals with the at-will disclaimer and employee handbook. And what's come up with the NLRB recently is that if you have that at-will disclaimer in your employee handbook, you should not have information in your handbook that says the employee agrees with the at-will disclaimer. You can have it. You can say we are an at-will employee, and all of that, and but you can't have them agree with it, because if you do that, that can violate the NLRB. If you intend to have enforceable contracts in your employee handbook, such as confidentiality, non-competition, or non-solicitation or arbitration provisions, those should be separate from your employee handbook. And the privacy aspect of that is related to the confidentiality provision. That's because you don't want to have to enforce your contract by suing on your handbook. I mean, for years and years and years, we have tried to say that handbooks don't create contracts. You don't want to present a situation where you're arguing that your handbook is a contract. And then finally, social media confidential information. So if you have employees in your workforce that blog for you, or that use have an online profile that is an on profile for you, and maybe they have a handle or password that they use for that online profile, you want to make sure you own that social media. And in order to own that social media, you have to have in your, like for instance, confidentiality agreements, that those passwords, those handles or profiles are confidential information, constitute social media confidential information. And you need to have agreements in place with your employees that do that kind of work, that they know that when they leave, the handle, the persona, belongs to you. Well, I've covered a whole lot in an hour, and I'm happy to answer questions. I see there have been a lot of questions about the data breach plans. There are, if you go online and you just Google data breach, you will find some very, very, very good information on data breach plans online. And I'm happy to, if you would like, I can send you the links to those things. But that's where I found a lot of information about data breach plans. And you have another viewer or listener that said that their insurance agent just covered this with her. But has some other questions about it. My firm does have some guidelines for data breach, and what I can do is put those together. You do have my email address there, so if you're interested in getting something like that from me, do email me, and I'll send something out to you. Likewise, if you have any other questions about anything we've covered today, I'm perfectly happy to help you out with that. And answer any questions that you might have offline. So I am done, and I thank you for your participation.
Thank you, Jean, for speaking today, and thank you, everyone, for all your questions. It was great to see all of the interaction from all of you. I just wanted to make a note that HRSimple.com is now approved to award SHRM CP SCP credits for all of our webinars. On the screen, you can see the event ID. Go ahead and write that ID number down, and then you'll enter that into your SHRM portal to gain your PDC. If you have any questions, my email is also there. On behalf of HRSimple.com and Schwabe, Williamson, and Wyatt, thank you for spending time with us today, and we hope you'll continue learning with us throughout the HRSimple.com webinar series.